case briefs, and so much more. LSData's got what you're looking for.
A Jewish family, the Blochs, filed a lawsuit against their Condo Association claiming religious discrimination when their mezuzot were removed from their doorposts. The association enforced a rule prohibiting objects outside unit entrance doors, but only during renovations, removing other items as well. The Blochs sought an injunction and damages, alleging the incident was a violation of the Fair Housing Act, FHA. The court examined whether the FHA prohibits post-acquisition discrimination and if there is enough evidence of intentional discrimination. It was determined that the Blochs can pursue claims of discrimination under Section 3604(b) and Section 3617 of the FHA, as well as their Section 1982 claim with additional evidence. The court required more evidence to prove intentional discrimination, but allowed the Blochs to proceed on an intentional discrimination theory under Section 3604(b), 3617, and 1982. The district court's judgment was affirmed on the Section 3604(a) claim, but reversed on other claims and remanded the case, deeming the grant of summary judgment too hasty. The Blochs were allowed to proceed if they provided sufficient evidence of discrimination, with the court citing evidence of animosity supporting intentional discrimination claims.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.